now invite the Russian Federation to take the floor.
Thank you, sir. We wish to thank the UN Secretary General Antonio Guterres, as well as other rapporteurs, for the assessments that they have provided about the role of reconciliation in the maintenance of international peace and security. Indeed, the achievement of a lasting national reconciliation is a key factor for a successful conflict resolution and for the prevention of relapse of conflict. The achievement of peace agreements and lasting post-conflict recovery and rebuilding is only possible when mutually acceptable solutions are arrived at amongst the conflicting parties, and these which are geared towards the long term. At the same time, a universal key to addressing domestic conflict is only lies through comprehensive nationwide dialogue. As practice reflects, this is the only way to ensure that there be a robust, viable, long-term solution regardless of which state is concerned. As is rightly noted in the concept note submitted for today's consideration, during post-conflict recovery, including post-peacebuilding, including regarding national reconciliation, what is of great importance is that both the government and society acknowledge their national ownership for lasting peace. This is an approach which is enshrined in the twin resolutions of the General Assembly and the Security Council on the review of the peace-building architecture dating 2016. This in particular means that the state bears the main responsibility for safety and security of the populace, whereas all population groups are called upon to acknowledge their ownership for supporting peace processes. The activities of the international community, including individual states, associations thereof, and the United Nations itself, should be geared towards facilitating the peace efforts of extra-state players. The United Nations in particular has all of the requisite tools to help states achieve national reconciliation. This occurs through the provision of the Secretary General's good offices, those of a special envoy and special representatives, United Nations peacekeeping and special political missions, as well as country teams. At the same time, we believe that it would be wise for the United Nations efforts to be focused on cooperation with official governments. Cooperation with various representatives on the ground can be done only under the coordinating role of national authorities. Furthermore, international community's assistance in delivering upon national reconciliation should both be apolitical and not morph into the imposition of generic solutions from abroad. Attempts to support a given party to conflict guided by one's individual interests only exacerbates division, obstructs the healing of wounds, and stymies genuine reconciliation. Mr. President, in this connection, it behooves us to delve into detail about the issue of the role of international justice and holding perpetrators to account within the context of reconciliation. Justice and reconciliation far from always go hand in hand. Often, the operations of international mechanisms for justice lead to further escalations in conflict within societies. At present, this is a pressing issue within a number of states in many parts of the world. We are bearing witness to political account settling with former opponents, with mechanisms of international justice being harnessed here at the United Nations. We believe that with each specific incident, there is a need to strive to strike the right balance between the restoration of peace and justice, and this despite the inherent difficulties in this process. In each specific circumstance, it is necessary to focus efforts on bolstering national judicial bodies. At the same time, we believe that the establishment of facts during judicial processes and holding perpetrators to account, as well as the acquittal of the innocent, can tangibly contribute to normalizing situations and can help to overcome hostile sentiment and resentment among parties to conflict. However, the only way to achieve this is provided these processes be apolitical and impartial. Unfortunately, international judicial mechanisms often manifest patently double standards. For example, the activities of the International Tribunal on the former Yugoslavia and the residual mechanism can hardly be deemed to be success stories in terms of the contribution to reconciliation on the Balkans. The unjustified prevailing inculpatory bent in consideration of cases regarding defendants of Serbian origin was compounded by a dearth of a genuine focus on casting light on the myriad crimes perpetrated by Kosovar Albanian field commanders. Clearly, attempts to pin blame for certain crimes on peoples, governments, and states as a whole foment tensions and mutual reciprocal mistrust in the former Yugoslavia. This revives protracted issues and interethnic strife in the region. Thereby, one cannot even speak of any assistance for reconciliation in this regard. It behooves us to note that a similar path was treaded by the International Criminal Court. The cases referred to it by the UN Security Council are being considered in a manner which is at variance with reconciliation objectives, and this worsens divisions among the warring parties. This is starkly evident on the Libyan dossier of the ICC. If we are to analyze on the whole the activities of international tribunals, one can arrive at the following conclusion. These are quite indirectly related to the processes of reconciliation in post-conflict societies. Rwanda's experience speaks volumes here. A significant role in efforts for post-conflict reconciliation was established by the fact that at the national level, a local justice system was established in the form of the semi-traditional gacaca courts in connection with the ineffective International Tribunal on Rwanda, which considered the cases of only the main organizers of the 1994 genocide. In practice, the gacaca courts should were not only to have carried out the mission of justice, but also to facilitated a reconciliation within societies by focusing and banking on the broadest possible inclusion of people in their activities, a public consideration of cases with individuals, and fair decisions and judgments being rendered. And this was facilitated by the idea of cooperation, active participation in the courts. The effectiveness of gacaca courts in 10 years considered approximately 2 million cases was very effective, and these courts spent 45-fold fewer financial resources than the ICC, which in 20 years of its existence managed to consider only 100 cases. The effectiveness of these courts testified to the effectiveness of seeking African solutions to African problems and the related approach. To conclude, I wish to note, in connection with the above mentioned, that we believe that leveraging institutes of international criminal justice in the context of post-conflict reconciliation should not be made an absolute. The damage wrought as a consequence could be far more significant than the added value. Thank you for your attention.
Thank you.